This is a lecture on Lesson Module 7, Civil and Administrative Law. Here are the objectives for this lesson module. I hope everybody would be able to accomplish these things by the time you're finished with this module. Okay, I start out here wanting you guys to recognize the similarities and differences between civil law or private law and criminal law, which is considered public law. And so what I've got on this screen is a copy of that, I guess you call it a bullseye graphic from your textbook. And it's got all the same information, well, most of the same information, but we are dealing with a different circle on the bullseye. So when we were doing lesson module 5 and we were looking at criminal law, we were dealing with the two most inner circles, core offenses, the mala in se, bad in and of itself, offenses that have a high consensus for moral outrage and punishment. And then the next outer circle, mala prohibita, which is all crimes, including the ones where there isn't, both high consensus and low consensus crimes. So that would be mala in se and mala prohibita together, those two inner circles. Those types of misbehavior are punished by government. That's why they are public. That's public law. Criminal law is public law because the government is acting on behalf of the community at large in punishing that behavior. With the next circle out, so that would be kind of the second circle if you're coming from the outside. That circle encompasses all social harm, and it's bad enough that someone can sue over it and recover damages for it. So it's going to exclude minor incidental contact with another human being where there's really not a whole lot of harm, just the tiniest inconvenience or unwanted contact. You move in a little bit and you get to things that are wrong, morally wrong, but the wrongness, the harm is just really to the individual who's experienced the harm and not to society as a whole. Now, you got to be a little loosey-goosey with that definition, as you'll see when I kind of get into it. Some of the harm that can be the subject of a private lawsuit can also be the subject of a criminal prosecution. So there is an extent to which these social harms that people sue over also are harmful to the community at large in the aggregate. If lots of people were being harmed in this way, that would be a real problem. So you'll see some overlap, but I wanted you to start with this bullseye and kind of recognize that we're moving out from the center of it to offenses that would not necessarily be subject to public prosecution. So we'll do another compare and contrast chart to kind of look at the similarities and differences between criminal law and civil law. And I want you to also recognize this as public law versus private law. So use those things interchangeably. So for criminal or public law, the parties in the lawsuit are going to be the government versus a defendant. So government versus non-government. An individual citizen is being prosecuted by the government. In civil law, it's private citizen versus private citizen. People are acting on their own behalf. I got a little asterisk there because it is possible for a government entity to be a party to a private lawsuit. So kind of keep that in the back of your mind. Doesn't happen often, but it does happen sometimes. Criminal law or public law seeks to deter bad conduct, punish it. Civil law isn't designed to be a punishment. It's really designed to sort of restore the harm that was done. It's a restitutive form of justice. So the outcome of a civil or private lawsuit is money damages most of the time. Sometimes you can get an order from the judge to specifically perform some contractual obligation. Most of the time, it's just a monetary award. Now, there are some torts, some physical and mental harm to individuals, personal injury cases, where the defendant's conduct is really, really bad. And depending upon that, a jury may award additional damages to the injured party in the form of punitive damages. So it's the jury's way of saying, we really want to punish this conduct. We don't want to just compensate the victim or the harmed party. We are trying to punish this behavior. So that does happen sometimes, but the standard of evidence is going to be different. And the U.S. Supreme Court or the court systems generally will scrutinize punitive awards to make sure that they are fair and that due process is being afforded to a defendant in those types of situations. In public law or criminal law, the burden of proof obviously rests on the government. You should have learned that with modules 5 and 6. You should know that by heart now. It is up to the government to establish guilt beyond a reasonable doubt. In a civil lawsuit, the burden of proof shifts back and forth. So the person who is asserting a claim has a burden to prove his or her claim. And once they do, the defendant has to act back. They have to answer for their conduct. And so it's not like in public law, the defendant doesn't have to present any evidence. They don't have to testify. A criminal defendant can just watch what's happening, have an attorney there to try to create reasonable doubt in the prosecution's case, but has no affirmative burden to present anything unless they're asserting some sort of affirmative defense like self-defense or some sort of justification or excuse. But that is not the case in civil law. A civil law defendant in a private lawsuit, if they don't answer the complaint, if they don't present evidence on their own behalf, they will lose and they will be subject to whatever award the judge renders or jury renders. So they can't just sit back and watch. They have to answer. They have to fight back. So that burden of proof, it starts with the plaintiff. Once the plaintiff presents enough evidence to satisfy a prima facie case, the burden then shifts to the defendant to respond and present evidence that counters the plaintiff's. And so the burden could shift back and forth throughout the trial. It goes kind of back and forth. And then in criminal law or public law, the prosecution's burden is beyond a reasonable doubt. But in civil law, the standard of proof is preponderance of the evidence. So what's happening in a criminal trial is a panel of jurors is deciding whether or not a defendant should be punished, is guilty. So do they have any reasonable doubt about the defendant's guilt? If so, the defendant won't be punished. And then burden is really just on the prosecution to establish that, to justify the deprivation of liberty or life. In a private case, with the burden of proof shifting back and forth, the jury is just there to kind of decide which side's more convincing. So has the plaintiff established a prima facie claim? Has the defendant responded? They're weighing the evidence. Like you can think of it like a scale. You know, which side does it lean towards? Is it more likely the plaintiff's right or more likely defendant's right? So that's what preponderance of the evidence mean, is which side does the evidence tip in favor of? In criminal law, the constitutional protections of liberty and life are afforded to criminal defendants. So that's what we studied in Module 6. The 4th, 5th, 6th, and 8th amendments to the Constitution are there, and they are applied stringently by the court system to ensure due process is afforded to criminal defendants. In private lawsuits, the Constitution, those protections that you see in those amendments, they don't really apply in private lawsuits. There are some kind of there's some interplay of them that's kind of beyond the scope of this course. But the bottom line, if you're trying to keep it simple, no, the constitutional protections for due process that are found in the Fourth, Fifth, Sixth, and Eighth Amendments do not apply to private lawsuits. However, and this is a big however, there is still a body of law known as civil procedure law that sets the rules of conduct of civil trials. And those rules afford fairness to defendants. So we still have, even in a private lawsuit, a requirement that the judicial system be fair. So a defendant is not going to lose a case to a plaintiff without having been treated fairly. So they have an opportunity to defend themselves. They have an opportunity to present evidence. They have a jury. They have, I think I may have already said this, but they have an attorney. So the fairness element is still there, even though the requirements of the Constitution, the Bill of Rights, those four amendments don't really apply to civil cases. In a criminal case, the defendant only can appeal an adverse verdict. The prosecution cannot. If they lose a trial, the defendant goes away and can't be prosecuted again by that same jurisdiction, and the prosecution can't appeal. A defendant who loses and is found guilty, yes, absolutely can appeal an adverse verdict. But in a civil or private lawsuit, anybody can appeal. You can even just appeal an evidentiary ruling. So it's kind of open season for civil appeals. In criminal law, I mentioned this when I was trying to describe the difference between public law and private law. With public law, you have a community that is seeking to punish misbehavior or deter bad behavior, unwanted conduct. So that's why you say this is public regulation of behavior. With private law or civil law, you have private regulation of behavior. And so you'll have a victim. The plaintiff has to establish some element of harm. And it's the type of harm that's really just experienced by this one person, and it doesn't really affect society as a whole. That's why it's not being prosecuted publicly. But sometimes what the defendant has done, if in the aggregate, if a lot of different people did that same thing, that would be bad for society as a whole. So in the aggregate, these private lawsuits do create a deterrent effect and tend to operate in a more public way. So as an example of that, say there is a terrible car malfunction and a car explodes and the driver and occupants die. Horrible, right? So the family of the victim sue the car manufacturer and demonstrate that there's been some sort of flaw in the design or assembly of the car. And the verdict is a huge verdict because you're dealing with a death or terrible harmful conduct, terrible physical harm to a plaintiff. And the word gets out, oh gosh, among other car manufacturers, if we design our cars this way, we'll get sued and have this huge judgment on us as well. Therefore, we won't do that. We won't make the mistake that this first car manufacturer did. So they learn from the outcome of these lawsuits what the consequences of their business choices would be. And they make their choices knowing that there's these private lawsuits, the outcomes of these private lawsuits. So in that sense, this private regulation of behavior has an effect on society as a whole. We'll talk a little bit more about that later. Okay, Just as with criminal law, there are types or categories of civil law. So we're going to see some similarities here. There's tort law, which involves harm, like physical and mental harm to persons, sometimes to property. That's tort law. Property law regulates the ownership, possession, and use of property. We're not talking about trespass here. We're not talking about harm to property. It's just the sort of the business end of property there. Contract law regulates business transactions. Family law, regulating family relationships. And then you have administrative law, which is actually not purely private. It's a hybrid of both public and private law. We're dealing with private citizens, but their behavior has an effect on society as a whole, and it is regulated by government agencies. And we'll get into that in a little bit. So we start with torts. Tort law, as we said in the last slide, regulates social behavior or misbehavior that poses an unreasonable risk of injury. So the award then is to restore the plaintiff, to put them in the position they would have been in had the defendant not been negligent or harmed them in some way. It's restitutive justice. So you're just trying to make up and compensate the victim for the harm they sustained. But at times, the behavior of the defendant is so bad that the jury can award a punitive damages award, so an additional amount of money, more than it takes to just compensate the plaintiff, because they want to deter another defendant from this type of conduct, to get them to see that this never happens again to anyone by anyone. So this punitive award is intended to be a deterrent and to punish the defendant. So you say, well, what the heck is a tort? You're talking about tort law. Probably should have started out with this. What is a tort? A tort is harmful behavior. It's pretty simple. Harmful behavior that isn't necessarily criminal. That's what a tort is. Harmful behavior that isn't necessarily criminal. Could be criminal, but not necessarily so. Just as with proving crimes, you had the 5 elements of every crime to establish liability, right? Actus reus, mens rea, concurrence, causation, harm. Guess what? Got the same thing with tort law. There are essential elements that must be established by the evidence before a plaintiff can recover any damages. So let's look at different types of torts. You have intentional torts, where the defendant meant to hurt someone. This is some examples of that are assault, battery. Assault is also referred to as intentional infliction of emotional distress. So there's no physical harm to a plaintiff, just mental harm. Battery would mean physical harm. So you can sue someone for battery. They usually go together, assault and battery. Trespass, that's harm, intentional harm to property. False imprisonment, that's kidnapping. It's just the form that you sue. When you sue someone, you don't sue them for kidnapping, you sue them for false imprisonment. Conversion is theft, suing someone for stealing from you. Negligence is another category, and here you don't have intent. This is where the defendant didn't mean to hurt anybody at all, but they owed a duty of care and they breached it. So they didn't do what they ought to have done, and as a consequence of that omission, they are legally liable to the victim. And this is, I'm breaking down the elements of negligence a little further. It starts with a duty of care. So the defendant must have some relationship with the plaintiff, owe them a duty. The defendant would owe them a duty to exercise reasonable care. they breach that duty. So they omit. It's a claim for omission, not an intended harm. It's an omission. They failed to do what they ought to have done under the circumstances. And it is a reasonableness test. So the jury is looking at what are the reasonable expectations of people and their interactions with one another. So the defendant owed a duty of care. This is something the plaintiff has to prove. Remember, the burden shifts back and forth. So to start out with, the plaintiff must prove that the defendant owed him or her a duty of care and breached it. And that breach factually or legally causes harm. So you've got that causation element similar to criminal liability. You have to establish, but for the defendant's omission, the plaintiff would not have been hurt, and that the harm the plaintiff suffered was reasonably foreseeable to the defendant. So that's factual causation, but for causation, and foreseeability or legal causation. Both of those must be established by the plaintiff. And then harm is a necessary element of torts, the same way it's a necessary element in criminal law. Harm to an individual or group of individuals that can be physical or mental. So that's your prima facie case of negligence that can be brought by a plaintiff against a defendant. And once the plaintiff presents evidence of all those four elements, the burden shifts to the defendant to answer and to present his or her own witnesses and evidence to counter one of those elements or establish some sort of defense. Strict liability is also part of tort law, and this is where that one of the elements is sort of automatic. So strict liability is involves certain, I wrote on here, consumer products. It's also like unreasonably dangerous products is what you think are just real risky endeavors. It's gun manufacturers, less an example you think of, or medicine, drugs. There are some other examples. I think your textbook has a strict liability torts, but in these situations, duty and breach of care is done. You don't have to prove, the plaintiff doesn't have to prove duty or breach. They just have to show I was harmed because of the defendant's product or activity because it was unreasonably dangerous. And the defenses to torts are very similar to criminal defenses. You can say, oh, the plaintiff contributed to the injury. The plaintiff was not exercising reasonable care for themselves. They weren't watching where they were going. That's why they fell. And so jury should not make me pay for all these medical expenses when the plaintiff had just as much to do with it as I did. That's a defense to a tort claim. And jury, in some jurisdictions, in some states, if the defendant can show the plaintiff contributed at all to his or her injury, the plaintiff recovers nothing. That's contributory negligence. So that is an absolute defense. The defendant just has to show the plaintiff contributed in some way to their own injury, and then the defendant wins. In other states, in other jurisdictions, juries can only provide comparative negligence, where they sort of assess, well, okay, plaintiff should have been watching where they were going, but the defendant is the one who didn't clean up the mess on the floor, and they should have. They're more responsible for the injury than the plaintiff is. So we'll say 60% of the expenses the defendant's going to cover, 40% the plaintiff will cover. So sort of splitting the difference, splitting up the compensation so that the defendant doesn't bear it all because the plaintiff did have something to do with his or her own harm. And in reality, people, every jury award works this way, whether you're in a contributory negligence jurisdiction or a comparative negligence jurisdiction. Juries are not stupid. If a plaintiff is asking for $500,000 in a slip and fall case, and yeah, the defendant business owner should have cleaned up the mess, but the plaintiff wasn't looking where they were going. Plaintiff's not going to recover everything they're asking for. They don't have to call it a comparative award. They're just going to award them less. So in the end, that's how it works out. And then there's, the same excuses and justifications that we learned about with criminal law. They exist for tort law as well. Tort reform is something we need to talk about because you've got a pretty big assignment with this module. I believe I've got an extended deadline for this module. I believe I did. Because I want you to really think about it. This is an important kind of emerging politically controversial area of law that I want you all to really consider. So what do I mean by tort reform? Tort reform is a group of ideas, this is what I have on the screen, that are designed to change the laws of the justice system, private justice, civil justice system, so that tort litigation and damages are reduced. And so it can take different forms. Tort reform can be financial, like caps, maximums. There cannot be a judgment in excess of, I don't know, $50,000 for this type of claim or $100,000 for this type of claim. Those caps on damages, that's one type of tort reform. Another type might be raising the standard of proof above preponderance of the evidence before someone can receive a punitive damages award. Or it could be, additional elements that have to be proven, just different. There are different ideas. It's not just caps on damages. There's a group of ideas. And the point is to make tort litigation more fair. And it's kind of up to you. Do you think this is fair? Do you think this is good for America, or is this bad for America? That's a matter of opinion. That's why this is a political issue. It's a public policy issue. What do we think is the right answer? A good reason to have tort reform popped up all at once on the slide here. I'll go through that. If you are for tort reform, I just noticed I have the for and against in the wrong windows. So ignore for and against and just listen to what I'm saying. If you are opposed to tort reform, it is because you are more interested in corporate accountability. You think about big, huge businesses with deep pockets who make decisions for their business based on the bottom line and aren't factoring in concern for harm to the public or harm to the consumer. So if you believe that tort reform is bad for America, it's because you want there to be greater accountability for corporate misconduct. You want to give a greater voice to consumers. Oftentimes, you might hear, people say, well, if you don't like the defendant's product, if you think it's too dangerous, shop somewhere else, buy somebody else's product. Well, it's not always that simple because companies can hold monopolies in certain areas of a state, especially in rural areas where consumers really don't have that much say in the products that they buy. So, and being able to sue a defendant for negligence or some harm is a powerful tool. And it gives consumers opportunity to hold defendants accountable for their economic choices that have caused harm. And tort litigation is a means of social control. As I explained, sometimes these awards that juries return are large, really large, and they send a signal to all businesses, not just the defendant's business, that if you do this thing, if you sell this dangerous product, or if you make this choice, you are going to be subject to an enormous jury verdict and you might go bankrupt, right? That's a deterrent. So defendants, businesses, companies watch the outcomes of civil lawsuits because they want to see what are the damages awards that may come as a consequence of this decision, this business decision. If I make this business decision, what are the economic consequences? And they include consideration of jury verdicts. So that will affect their choices. It can be a deterrent. That's social control, as I wrote on here, through the pocketbook. The criticism of tort reform often is that it's jackpot justice. I'm sorry, I'm getting it mixed up again. These large verdicts are known as jackpot justice. So yes, they may provide a means of social control through the pocketbook, but it's not fair because the awards are huge for relatively minor incidents. And the example you can look at are, the TV commercials, like for various lawyers around South Carolina. I got $10 million in my car accident case, thanks to such and such lawyer. And you think, good gracious, who's given $10 million for a fender bender? What jury would do that? And that's jackpot justice. That's not fairness. So a criticism of these large verdicts is that it's not fair. It's like they won the lottery, that's not fair. So that's a criticism and a reason why you might want to have tort reform. And you can also think that maybe these private lawsuits are better than government regulation of businesses. There is reason to say that this is a more efficient process at holding private businesses accountable for their misconduct. There's no bureaucratic red tape involved. A plaintiff hires an attorney, the attorney files a claim, and in, maybe 3 to 6 months, you're going to get a pretty big settlement. The defendant's going to learn from that and change his behavior. Done. You've accomplished you've accomplished a lot for the good of our community when you can get something done quickly and efficiently. But at the same time, it may be better for the government to handle the regulation of corporate misconduct. And so let's look at the other side of the argument here. Why might you want to have tort reform? Well, this is sort of the counter to corporate accountability. When a jury awards a really high verdict in a case, then so the defendant has to lay out, I'll continue with my example, $10 million. Well, it doesn't necessarily hit the bottom line of that business because they can just raise the prices of their products. So they raise the price, they cover this business expense, and who pays the judgment in the end? Consumers do. So the corporate the corporate offender here didn't actually get punished. The consumers did. Now they got to pay more for whatever product caused harm or for the other products. So this is, jury verdicts, these judgments against the defendants are on the budget, they're on the balance sheets of the companies. They're considered a business expense. And so how do businesses handle expenses? Well, they raise their prices. So in the end, who's paying the judgment? Well, the consumers are, not the company. So maybe tort reform will keep prices lower. And that comparison chart that I showed you earlier, I was talking about how the standard of proof in public law is higher. It's beyond a reasonable doubt, right? The government has the burden of proving guilt beyond a reasonable doubt. In a private lawsuit, the burden's lower. is its preponderance of the evidence. Is the defendant more likely than not guilty of this tort? So the standard of proof is lower in private civil lawsuits, but the punishment is still as high as it would be. Whatever fine the government could impose upon a car manufacturer for making its car unsafe might be actually smaller than what a plaintiff might recover, especially in a class action lawsuit. Those verdicts are really, really high, but the burden of proof is lower. So you get the same result, but it's easier to get in a civil lawsuit to get that result because your burden of proof is lower. The standard of proof is lower. So in that sense, then it isn't fair. Tort litigation isn't fair in some instances, and reform might be a good idea. It has worked out that small businesses were bankrupted by a huge jury verdict. I don't know how often. I can't give you the statistics on that, but you can make the argument that these big jury verdicts are not fair because it can put someone out of business for a relatively minor mistake. One thing I have witnessed and can tell you happens is that some businesses will refuse to put up a brick and mortar location in jurisdictions that are sort of notorious for having huge jury verdicts. I lived for a long time in Alabama, and there were a few counties in the rural parts of Alabama where big companies would not go. They would not establish a location in those jurisdictions, do any sort of business in those jurisdictions for fear of getting sued and having a jury return an enormous award that bankrupts them. So it cuts against having new businesses come into a community to provide, jobs and tax money. So there are reasons why you want businesses to come to your community, and if your community becomes known for having these high jury verdicts, you're going to run off the businesses. So it has this sort of negative impact. Tort litigation has a negative impact economically on your community in that way. So that's a reason to be in favor of some sort of caps on awards, some sort of reform measure. Tort litigation does make lawyers quite rich. They wouldn't have the money to pay for those commercials you see on TV if they weren't getting these huge jury verdicts. The lawyers cut in most jurisdictions for a pretty big, personal injury case. Sometimes a lawyer will negotiate like a 40 or 50% cut. So yeah, hey, I got $10 million from my car accident. Wrong. You got 5 million, and so did your lawyer who didn't get hurt, So the lawyers get a big cut of these big jury awards, which means the money's not really getting to the person who was harmed. You want lawyers to be compensated for the work that they do, but it really is a jackpot for them if they get these huge verdicts. Okay, so I have the for and against words on the slide. They're backwards. So if you're studying and you're copying down this PowerPoint slide right now, put against over the left column and for. So for tort reform is on the right, against tort reform is on the left. And I'm sorry about that confusion. Oh, I forgot about that last point, but I think I made it in the discussion. Okay, next area. We're moving on from torts now to business. So contract law. It's pretty obvious this is the regulation of economic transactions. It can involve just an exchange of services. It's not just about buying and selling goods. It can be exchanges of services. When it does involve the sale of goods, the law takes the form of statutes. There's something called the Uniform Commercial Code. Every state in the United States of America has its own version of it, and there are very few differences state to state. It's very uniform, okay? It's a statutory law. Area of statutory law is in the sale of goods. It's very standardized, and that makes sense because Especially these days, economic transactions go all over the world, definitely all over the United States. It's not local anymore. So we have a standard sort of code that people operate under when they exchange goods. What is a contract? Contract sets the terms of the exchange, of the transaction. Contracts do not necessarily have to be in writing. There are certain contracts that do have to be in writing. Many of them do, but not all of them. So I want you to make a note of that. In order to be enforceable, a contract does not necessarily have to be in writing. It can just be an exchange of words. Contract law does carry out some measures of social control because it provides predictability in the business dealings, person to person, company to company. And I mentioned this before. This is uniform across most states, every state in the United States when it comes to the sale of goods. The rules are the same. And that's a good thing. It allows economic transactions to cross state lines, to cross national lines. Everybody knows what the consequences of their choices will be. It's less risky then to engage in business transactions. Well, that fuels a healthy economy and allows businesses to flourish when they have that element of risk taken away, and they can trust what the outcomes will be. Their contracts, if these boxes are checked off, will be enforceable. So what are those boxes? What do you have to make a contract enforceable? A meeting of the minds. People got to know what they're getting into. There will be an offer by one party to the contract, and acceptance by the other party to the contract, and the offer and acceptance are known to be what they are. I know I'm being offered. I know my offer has been accepted. And it is being done voluntary. No one's being forced into the deal. No one's under duress. Both parties are acting in good faith. There's no fraud at work here. After the meeting of the minds, for a contract to be enforceable, somebody's got to do something. They have to act in reliance upon the existence of the contract. Doesn't necessarily have to be fulfilled completely, but one party to the deal has to take some action in reliance upon the existence of the contract. And the contract has to be illegal. Courts are not going to enforce, like, a contract for the sale of marijuana and, still in the state of South Carolina, that contract's not going to be enforced. So it's got to have a legal subject matter. Parties have to be of age. It's got to be legal. So once you check off all those three boxes, you've got an enforceable contract regardless of whether it's in writing. And you can sue for breach of contract. The breach is the failure to perform. And if the plaintiff establishes the failure to perform a valid contract, then the jury will award damages that will restore the plaintiff. And I wrote on here, to status quo ex ante. That means put them in the position they would have been in had the defendant not breached the contract. It's a compensatory form of law. But then there are occasions when courts will order the defendant to perform the contract. That's called specific performance. The image you see on the screen is not from a horror movie. It's a silly illustration of a very famous contract case called Hawkins versus McGee. If you click on a link, click on the well, I guess you can't, because this is a recorded lecture, but if you Google that case name, it'll take you to a YouTube video from a movie called The Paper Chase. And in that little video clip, there's a law school classroom, contract law classroom, and the professor calls on a student to tell about this case, Hawkins versus McGee. And the student has a terrible time trying to tell about the case. But it's just, so the professor takes over, and it involved a surgery gone wrong where hair started growing from the palm of a boy's hand. So it's known as the hairy hand case. And it's kind of a funny case. If you want to get a flavor of contract law, you can click on that link, hear the law professor describe the case, and it's silly. It's real. It really happened. But you kind of can see how a contract law case worked out in a situation where it wasn't a personal injury lawsuit at all. It was a contract law, breach of contract case involving physical harm, but plaintiff won. Property law. So we're not talking about harm to property. That would be trespass, which is a tort. We're talking about laws that regulate the ownership, use, or possession of property. It can be real property, land, homes, personal property like your cars, your computer, your stuff. It can be intellectual property, so your ideas. There are a lot of different types of property rights. I've got a list in this PowerPoint. You don't have to memorize what these all are. I just wanted to introduce it to you. Freehold and non-freehold interest. Freehold means that you own what you own for the rest of your life. Then non-freehold means you're just renting it. So you're really just using it, paying for the right to use it. Fee simple means you own it for your life, but you have to give it back after you die. Fee simple absolute means that you can pass the property to your heirs. Tenancy in common, this is versus joint tenancy. Tenancy in common is really just applies to real estate, and it's where husband and wife or partner and partner own their property equally. They both have 100% ownership interest. So it's not like one partner owns 50%, the other partner owns 50%. They each own 100%. That's called tenancy in common. They both have full use, full ownership. There are property interests in the air above, real estate, in the ground beneath, real estate. You can gain property rights from squatting on property that you don't own. This happens sometimes where property is abandoned by its owner and someone else kind of moves in on it, starts using it as if they owned it for a lengthy period of time. And if it's long enough and the real owner, title owner, truly abandoned it, then the one who's using it keeps it and kind of has the benefit of a possessory interest in the property, a use and an ownership interest in the property. A lot of utility companies have this. They're called easements, a right of access to property that is not owned by them. Bailments, that's the property interest that exists when you temporarily give over possession of property to another person for a specific purpose. Intellectual property interest, I put this on here again because intellectual property is its kind of its own little area of law. It has its own court system. It has, the patent law court system. It's a very nuanced and specific area of the law. You can actually get a special law degree just to practice in intellectual property law. So it's kind of a unique thing that most attorneys are not qualified to deal with unless they get this special degree I referred to. Oh, I want to go back, explain that graphic again. So like you have the infamous Hairy Hand case, the Hawkins versus McGee. That is a picture of something called the Nyack House in New York State. And I thought it would be a fun extra credit assignment for you all. I'm doing this kind of on the fly. You won't see this on Blackboard. But if you're listening to these lectures like you ought to be, I want you to Google this case, Stambovsky versus Ackley. So you put that in your search engine. It's going to pull up a copy of the case. You read that case. It is a property law case. And there is a line in the judicial decision where the judge is quoting a pop song. So read the case. And when you find that line from that song, I want you to copy it, paste it into an email, and send it to me. That means you actually read the case. It's a fun case to read. It's actually kind of humorous, and it's something you might have heard of before. So send me that email, and I'm going to give you extra credit points. Probably like, I haven't officially decided, but it'll probably be something like 5 extra points for your lesson module assignments for this one lesson module. So there's your little extra credit assignment. Find that hidden line from a popular song buried in that Stambovsky versus Ackley decision. It's a fun read regardless. Family law. This is what you think it ought to be. These are laws regulating family relationships. You're talking about adoption and marriage, and unfortunately, sadly, probate law too. So regulating the distribution of property upon death. It is conciliatory law, meaning this is not about assessing blame or providing restitution to a harmed someone who's been harmed or victimized. We're just trying to reach an agreeable settlement. As I've already said, this involves marriage, adoption, estate, and probate matters. There are important, dry, sort of boring tax implications. And that is one of the ways that family law is a type of social control. Depending upon your marital status, the way you pay your taxes changes. And there are a lot of tax benefits that come from having children. So society values the family as the heart of any community. I wrote in here, the scaffolding of society is the family. So there are tax laws that create incentives for people to get married and have children. So that's one of the ways that we're regulating social behavior is our laws that incentivize the formation and support for families. Marriage laws vary a lot state to state, but it is a matter purely for the state governments to regulate marriage. That's just an example of like something some states require you to get a blood test before you get married. That's an example of marriage law that varies state to state. The right to get married, though, your textbook goes into this in more depth than I was expecting it to. It does have constitutional implications, and you should know this, that the right to marry is a fundamental right, regardless of your gender or race. So states, yes, they have the power to regulate marriage, but they cannot deny any person the right to get married to the person, whoever they love. Okay, so now we're getting into administrative law, and this is where your big assignment comes from for this course. I'm asking you guys you've got options. You can read a book, watch a movie, or do a heck of a lot of internet research about a particular case that involved well, to put it short, toxic dumping of chemicals on some ground that was located next to a water source, the Aberjana River, in Woburn, Massachusetts. Some industries had dumped the byproducts of their company onto the ground, and those chemicals leached kind of down into an aquifer that ran underneath the ground and fed into the river that's provided the drinking water for a community there. And a lot of people got really, really sick. Some people died because of exposure to these chemicals. And so an attorney named his name is hard to say. I think it's technically Jan Schlittman, but they call it Jan Schlittman in the movie anyway. So John Travolta plays the attorney, and he takes on this case, and it implicates administrative law because it involved the Environmental Protection Agency. When they learned of the situation, they did their own investigation of the activity. And at the same time, Mr. Schlitman was also prosecuting a private lawsuit on behalf of the families in that community against these companies. And it's a really interesting case because you get to learn about what the families, the people who were harmed, really wanted to have happen. You know what the government acting on behalf of the community wanted to have happen. And then you have this private attorney who had his own agenda, and affected the whole situation affected him very deeply too. So you need this information as a backdrop before you get started on that assignment. I want you to understand what we're talking about in terms of administrative law. And I'm going to kind of tie in that story as I go through this so it'll make more sense to you. Administrative law is a blend of public and private law. And you'll understand that when I'm done better. Just want you to know that going in. Administrative law is the stuff of public administration. So you can get a degree in college at Lander University in public administration. And that degree is going to teach you how public policy gets implemented in the real world. And it is implemented by agencies, by private agencies. But public administration is also a practice. It is the business of implementing public policy. So it's kind of got this twofold nature. It's an academic discipline that you study, but it's also something you can get a job doing. So public policy that is set by our elected representatives gets carried out by organizations known as agencies, administrative agencies. Other than just the top management, the employees who work at these agencies are private citizens, but they are funded by tax dollars. So that makes them public. They are implementing the policies that govern society as a whole. So it is public in that way as well. And but then the agencies, the internal structure, upper management, middle management, and then regular day-to-day laborers, that sort of structure with the chain of command, that's the same as a private organization would have. So you've got some overlap between private and public when we're talking about administrative law and agencies. There are a lot of administrative agencies you can click on. Well, you can. I keep forgetting that this is a recorded lecture, so you can't click on the link, but there are over 400 government agencies in the United States of America, and it is sort of criticized as being the fourth branch of government. It is not. There's nothing in the U.S. Constitution about establishing administrative agencies at all. It's kind of assumed that they're going to exist, but they are not an established branch of government, so don't be fooled about that. These agencies, I keep saying government agencies, but it's because they exercise government power. They're delegated the power to take actions that the government would otherwise be taking. And they're very specific. Each agency has its own little area that they deal with. And you can look at that graphic and see the Department of the Interior there in the middle. It's got a buffalo on it. So what are we dealing with? Wildlife. You see the U.S. Forest Service there. So you're obviously talking about agriculture or trees in that particular situation. National Park Service, they govern all the national parks. Get it? NASA, space. So they each have their own little specific area that they deal with. How did we get to have so many administrative agencies? That's what this slide's about. Before the Civil War, we didn't have them. There were a few, I think 3 agencies that George Washington established in 1789. Okay. I think it's, if I remember right, Secretary of Treasury, Alexander Hamilton, right? Is it Secretary of War, Secretary of Defense? Can't remember. And then Secretary of State was Thomas Jefferson. Okay. So he set up 3 agencies. Constitution didn't tell him he could do that. He just did it. And that kind of laid the basis. That's the tradition that was established by the first president of the United States, was to have these support agencies that would help the president get his work done. But there were still kind of just a few of them. But the national government was really small early in our history, so we didn't really have a need for a lot of agencies. But during the second half of the 1800s, during the Second Industrial Revolution, everything changed. Um, we had been practicing laissez-faire economics, unrestrained capitalism, but the businesses that were flourishing because of that policy um, stopped being accountable to their laborers and to the public as well. And that's what these images on the screen is meant to illustrate for you. The children at the bottom of the screen worked in a factory, and they are filthy and they are too young to be working. Child labor was fairly common in big urban cities because of the poverty rates. A lot of children, especially children of immigrants, had no choice but to go to work, and they were small, so they could fit into tiny places that adult hands could not reach. And they had to do really dangerous work, and they worked really long hours, and they were not fed. Their welfare was not provided or looked out for. So this is exploitation, plain and simple. Some companies were notorious for exploiting children, and safety regulations did not exist. And as a consequence of that, poor economic decisions were made. And I believe I could be wrong, but that could be a picture of I think it's a textile company in New York City. A lot of immigrant women worked inside, and oh, I'm probably getting the story wrong, but they may have been locked in. I'm not sure. But there was a terrible fire, and they all died. So there's reason now we see to create some sort of economic incentive for companies to make better choices that uphold the safety of their work environment, the safety of the products they make. And the desire to bring about that change came through the progressive era movement to create some sort of social justice, justice among the poor, treating them fairly, giving them fair wages, fair work hours, a safe work environment. Children can go to school and not work in dangerous situations. So another consequence of laissez-faire economics was a concentration of market share in, one or two businesses and those one or two businesses sort of worked the system so that small upstarts couldn't afford to get into the area. And so government, particularly under Theodore Roosevelt, went to an effort to break up these big companies and allow for small businesses, new businesses to come in and restore the competition in the marketplace and that would, hold prices down lower, give consumers choices, give employees choices about where to work, and make the economic system in America more fair, more just. In the 1930s, during the Great Depression, President Roosevelt established new agencies to create jobs. And then shortly after FDR kind of got involved, Congress started creating agencies to perform the policy implementation that required a technical expertise, things that the actual members of Congress didn't have the time or the knowledge to do themselves. So they created agencies to do those things and delegated the power to make laws, enforce laws, adjudicate violation of laws. They delegated all those powers to these agencies. And because of those reasons, this desire to bring back some fairness and competition to the marketplace, to protect laborers and consumers, to create jobs, and to handle the new technologies of the modern society. All of those things contributed to this explosive growth in the number of agencies that we have in the United States. And we wind up with hundreds and hundreds of agencies that are doing most of the government work in our country. And the U.S. Supreme Court weighed in on all of this in the 1930s and kind of gave its constitutional stamp of approval on their existence. So all three branches of government kind of got involved to allow for this to develop. It really was a consequence of demand. It was absolutely necessary for our country to have this administrative state develop. So now we're going to look at, what is the actual function, the day-to-day functions within the agencies. Well, it isn't completely, they don't operate independent of the government at all. Congress passed the Administrative Procedures Act, I think, in the 1940s. And those procedures govern the work of the agencies. It's kind of a big piece of big body of law, a big piece of legislation with a lot of detailed laws, detailed little nuanced regulations in there that govern what agencies can and cannot do. It starts out, so Congress can create agencies, but the president can also create agencies. So agencies can come from either branch of government. But let's work from Congress for a minute. Congress, our elected representatives, come up with a new public policy that they want to see carried out, presumably because their constituents have demanded it. So people say, they call their congressman, say, hey, we want this done. Congress says, great, let's get it done. We're going to make this our new public policy. They pass a law, but this involves a lot of expertise that members of Congress are not qualified to do. So they're going to create an agency to do it. And they vest this agency with the power to make law, to make rules that carry out this public policy. And that's what delegation means. They are passing down. Congress has the power to make laws, but they delegate it to this agency because that lawmaking involves some expertise that they just don't have. So that's what they hire. There's usually the president appoints and Congress approves the head of the agency. And then the agency hires the head of the agency, then hires the staff, and they do the business of writing these detailed regulations to implement the policy Congress desires. The laws they write, they can't just make up and impose on their own. They have to include the public in what they're doing. There's two different ways of including the public in it. It's through notice and comment rulemaking, or it can be through negotiated rulemaking. We don't have to really go into a lot of depth on what that means, but what you want to know is that the staff members of these agencies work with the businesses they regulate to come up with the rules that govern that business and the other businesses like it in that same area. The rules they write then are codified in a book called the Code of Federal Regulations. So this is statutory law, not common law, not constitutional law. This is statutory law in the Code of Federal Regulations. The executive power. So the president forms executive agencies. They're known as the members of the cabinet. So there's 15 executive agencies. The president names the secretary in charge of the agency. The Senate approves that appointment, and they form the cabinet that meets with the president on a regular basis. Those agencies are then delegated the power to carry out some executive functions. Judicial power. Some agencies have their own little court system inside them. They're called administrative law courts. And what they're doing is interpreting the Code of Federal Regulations and applying it and enforcing it against the businesses that are being regulated by it. So it's this own little separate court system. It's not an Article 3 court like we learned about in, I think it was Module 4. We're talking about a separate court system that administrative agencies will develop within their own roof that handles these enforcement actions and interprets the regulations and decides whether businesses will be fined for violation of a regulation. And here again, I'm emphasizing these agencies do not work on their own. They are not independent of the government. It is not a branch of the government, like I said at the beginning of this lecture. It is not a branch of the government, but they are not independent of the government. They are overseen by all three branches of government. Congress, they start out with delegating them. They choose what powers to delegate to the agency. And once the agency gets started, they've got to report back to Congress the business, what they've done. They report back their own activities. They get audited by Congress. Congress handles their funding. You see a picture of there on the screen of the EPA, the head of EPA there is testifying before Congress, answering questions to members of Congress about who knows what. I'm not really sure the subject of that hearing. It's just an example that Congress does a lot of the work of Congress is actually overseeing the work of the agencies they've created. Executive, the president does the same thing. The government, I think it's the government GAO, Government Accountability Office, Office of Management and Budget. There are all of these arms of the executive branch whose job it is to oversee the work of government agencies. And then courts, they have an oversight power over agencies as well, because they will hear appeals. If a business is fined by an administrative law court, the business can appeal the administrative law judge's decision. Because see, there's no jury, there's no public jury in an administrative law court. You just got this one judge. Now, he's an expert. He's probably a scientist in some field, or she, a scientist. They have a technical expertise that applies to the particular regulation. But if and it could be a panel of judges too, it's not necessarily just one, but whatever decision that agency makes can be appealed to an Article 3 court to have that decision reviewed. And that decision can be overturned by an Article 3 court. And so that gives the judicial branch oversight power over the work of agencies. Before I end the lecture, I want to point out one quick thing. Your textbook has something a little bit out of date in it, and it has to do with this administrative law situation. It says that the decision of an administrative agency won't be reversed by an Article 3 court very often, because Article 3 courts tend to apply something called Chevron deference. So they'll defer to the decision of an administrative agency because the administrative agency has the expertise needed to determine whether a violation of a regulation has occurred. It's not a legal decision. It's often a very factual, technical decision that lawyers and judges aren't equipped to make. So there was this deference that was afforded to agency decisions, and it kind of, the precedent for giving that deference was set by a decision involving the Chevron company. That's why it's called Chevron deference. It was a 1984 decision of the U.S. Supreme Court involving the Chevron company. But last summer, last month, I believe it was in July, it might have been in June, the U.S. Supreme Court overruled the Chevron decision. So that deference now is kind of up in the air. We're not 100% sure what amount of deference the Article 3 courts will now have to show to agency decisions. That's going to kind of be fleshed out in the future. But I just wanted you to know the textbook is slightly, by like a month or two, a little bit out of date on that one area. Okay, so that's the end of the lecture. Now I want you to go back and look at the assignment that involves that case I told you about with the dumping of chemicals in Woburn, Massachusetts. That's going to pick up where this leaves off. Do we think it is better for an administrative agency such as the EPA to handle that type of corporate misconduct? Or is it better for private citizens to handle that through tort litigation? If you have strong tort reform measures in a community, it will be harder for the private citizens of that community to um, to deal with corporate misconduct. They will be less equipped to punish it or hold the companies accountable for their misconduct. If you don't have tort reform, um, then private citizens will find it easier to do that work, but it may not necessarily be a good thing. You decide that. And you're going to apply your opinion or base your opinion off this particular case that is a true story turned into a book and then turned into a movie starring John Travolta called A Civil Action. So open that assignment now and read through the instructions. And if you have questions about what to do or what the expectations are, please email me and I'll be glad to explain it over again or answer specific questions because I may not have explained it well enough to start out with. And also, if you have any questions about any of this, you can get in touch with me for help. But that ends the lecture. Thank you.